Hey everyone, have you ever been in a store, reached for a product, and then done a double take, realizing it's not the brand you thought it was? That little moment of confusion? That's exactly what we're diving into today. We're going to be walking the trademark tightrope to figure out a really crucial question.
Right, that's the big one. That split second of confusion is the battleground where multi-million-dollar trademark lawsuits are fought. So, what exactly is the legal line between a clever inspiration and a flat-out copy? Let's get into it.
So before a huge, lengthy trial even begins, a company can ask a court for something called an interim injunction. You can basically think of it as a legal pause button. It can stop a competitor dead in their tracks if the court thinks there's a good chance they're infringing on a trademark. But, getting one isn't exactly a walk in the park.
A judge has to weigh a whole bunch of factors, and it's not a simple checklist either. It's a real balancing act. They have to ask, is there a real case here? Is there a genuine risk of confusing people? Who gets hurt more if we press pause versus if we don't? And this is a big one. What's best for the public?
Okay, so that's the theory. But how does this all play out in the real world? Well, let's pour ourselves a drink and take a look at our first case straight from the top shelf.
On one side, you've got a very well-known whiskey, Blender's Pride, and on the other, a newcomer called London Bride. And right away, you can see the issue, can't you? It's that one very powerful word they share.
So the company that makes Blender's Pride, Pernod Ricard, they were not happy. They took London Pride to court, arguing that the new brand was basically piggybacking on their key word, pride, and even said the packaging looked too similar. They wanted sales stopped immediately.
But here is where the court's thinking gets absolutely fascinating. The Supreme Court's decision came down to this. They said people who buy premium whiskey are savvy shoppers. They're discerning, they pay attention, they read the label, and they aren't going to be easily fooled. And just like that, the injunction was denied. The court ruled that even with the shared word, the brands as a whole were different enough that this discerning consumer wouldn't get mixed up. So London Pride got to stay on the shelves.
Okay, now let's switch gears. We're moving from the liquor cabinet to the medicine cabinet, a place where a simple mix-up could have far more serious consequences.
And this is the question that just flips the whole script. What happens when getting the wrong brand won't just ruin your evening cocktail, but could actually seriously put your health at risk? All right, check out these two products. We've got Istamet, a drug for diabetes, and Indamet, a treatment for asthma. Just look at those names. Say them out loud. Istamet, Indamet. They are incredibly close. Now, imagine hearing that over a bad phone connection, or trying to read a doctor's hurried handwriting. Now, this is a total 180 in perspective. The court's language here is so powerful. Forget the discerning consumer. When we're talking about medicine, the #1 priority is making sure there is absolutely zero chance of confusion, because the consequences are just too high.
So it's probably no surprise that the outcome here was the exact opposite. The court granted the injunction, pulling Indamet off the market while the case was sorted out. The key takeaway here is that the legal test itself gets way stricter when public health is on the line.
So we've got two cases, two really similar sounding names, but two totally opposite results. What gives? Well, it all boils down to a core rule in trademark law that we need to talk about.
The law is actually pretty clear about this. You can't own a common word. You can't trademark the word apple if you're selling, apples, or the word fast for a speedy delivery company. These words are either generic, or they just describe what the thing is or does.
And you see this happen all the time in the pharmaceutical world. A drug with the generic chemical name Nemesilide gets a brand name like Nimulid. See how the brand name is just pulled directly from that generic descriptive chemical name? It's totally standard practice.
And this is the common thread that ties both of our cases together. The court decided that the word pride is a common descriptive term in the liquor business. In the same way, parts of drug names like met are often just bits and pieces of their chemical compounds. In both situations, the shared part was a common word. So what was the game changer? It was all about the context and the risk involved.
This table really just lays it all out, and the contrast is crystal clear. The whiskey case, the stakes were commercial. The consumer was considered savvy, so the court used a standard legal test. The pharma case, public health was on the line. The consumer could be literally anyone, and so the test became incredibly stringent. The outcomes, worlds apart.
So if you take away just one single thing from this, let it be this. When a court is trying to figure out if two brands are too similar, the product, the customer, and the potential for harm, they change everything.
In the world of trademarks, context is absolutely king.
So, I'm going to leave you with this question. Next time you're out shopping or just scrolling online, take a closer look at the brands around you. Now that you know the rules of the game, which ones do you think are walking that very fine trademark tightrope? Think about it.